Hello, it is Matteo, the victim of this criminal justice in a way, who follows my blog, of course know what I'm talking about. Sorry about the scratch a bit. uh, I already received many emails about my case, saying people, ma how can prove and the Employment Tribunal and Employee Appeal Tribunal is corrupted. Well, I can prove because I know the law. It's hard this to let understand because people say, well, it's easy to accuse the tribunal. There is no easy to accuse the tribunal. I was not doing this video if this criminal justice was working and this puppet government could listen to me. Hope you can hear my voice. Anyway, just I want to just make some summary. Because there are a lot of video will come out, will come out of in the future. This is the Employment Tribunal decision from my is in Watford, the criminal judge of always. The outcome is very very funny because he strike my claim, my hearing on the Rule 37. Just I want to point out this. I brought many claims in tribunal, disability discrimination. Unfortunately, I recover anyway. And whistleblowing, which is very important. So why is very important? Because I was as I have a lot of experience. I've been working many years in aviation. As my ex-employer never supplied the right training to fuel aircraft was not my problem until when I was sick home. And they sent me the letter of gross misconduct. So I was sick home. Instead to be close, to say, hello Matt, are you okay? Like they try to suck me home. It's on the blog now, I have not the photocopy, but it's there. This is making me very, very upset. So I mean, you don't apply the regulation of health and safety in aviation. After you blame me, I have no respect the health and safety regulation, and I send some contact, I don't know, they involve me in some false communication with British Petrol, Total, which is the group which I was working anyway. This is absolutely disgusting. Anyway. That's why I claim whistleblowing, because they don't apply any health and safety training course. As I mentioned in my first video about the disaster Gulf of the Mexico, which is the same reason, because this big oil company apparently they spend the money for I don't know for what, but never for proper training health and safety anyway. Well, this we'll talk next video anyway. What I want just answer my these people which they email me, a lot of people. It's about 35 people anyway. The Employment Tribunal work when you claim, you make your claim, you disclose your document. The official document for the claimant is 81, and the respondent which respond at your claim, try to defend anyway, is 83. 83 form on my disability discrimination, the respondent has wrote accept I was disabled at the time. It's on my blog, the photocopy of what the respondent say. After a few months, the respondent changed mind. Look, a second. You have not provided your consent for our client to obtain a copy of your medical report as a request. Right. I did. This is the proof. Many times I did. But the tribunal, the case management, did not see this, the criminal judge as well. Anyway, I want to talk about what is the outcome from the decision of this strange, this man. I don't want to call it criminal, no, because could take legal action against me because it's never mind. I mean, we have been hearing the second one of my vestibular crime, exclusive vestibular crime. It was on 29, also on 14 of March, 2017. 17, exactly. This judge wrote a lot of bullshit, false. For what he wrote here, he should be in prison for all life. Hope so. I will push for this. He strike out to me my claim on the Rule 37. Okay, I explain what is Rule 37 is when exactly you bring some claim in tribunal which would be scandalous, unreasonable, or vexation. And this is, of course, because you probably want, or some employee want bring the proper employee to get some benefit, some money. And of course, the judge, when asked the proof, strike out for this. Plus, if you have no complete with the order of the tribunal, but this is not my case because I brought this claim, which was exclusive of whistleblowing on this day, and not for discrimination. This that could have been hearing in later April anyway. What's happened? Then he strike out on Rule 37 for this reasonable, scandalous, blah blah blah, which I don't think is the case because my whistleblowing claim is very relevant. Of course, it's relevant. I have the letter sent to me from Civil Aviation Authority is the Keith Andrea Ines, which is the top one of, and he say the allegation you made regarding aircraft fuel refueling at Heathrow Airport has have been investigated, and I would like to thank you for bringing your concern to us, to our attention. We have taken appropriate action as a result. So I mean, my experience in aviation was, was good. Was right. So this is first lie from judge. So number one, criminal judge always. This is why your first lie. He say I did not comply with the order from a tribunal. He say he sent the order to me. This is a second lie, because I give my authorization to access medical report, but not just this year. I did it back in 2015. On my blog there is the proof. plus there is the letter I sent to the tribunal at the respondent with recorded. And I sent the letter, I complete. Was on the other side, I did not complete. This is number 2. He did not complete. The respondent has no complete with the order and less order. And the management team, the case management team, which I told them was blind and deaf. The judge was blind and deaf. Anyway. In my application to strike out the respondent before the hearing, I wrote and the respondent has not complete before dated 5 of December 2016 and 11th of January 2017. I told the tribunal is blind and deaf. But the respondent, which is the solicitor Turbo Villas in Oxbridge, Mr. Jones, say on this email sent to me at the tribunal, which is recorded, and the tribunal will be aware that the respondent reply both of the tribunal letters dated 5 December 2016 and 11 January 2017 by email on 8th of December and 11 of January 2017. Respectively, we have confirmed the preliminary hearing on 14 May 2017. This is what he said the respondent. The tribunal has got this. This is absolutely lie. Why? Because I'm not stupid, I'm more intelligent. I wrote the database access compliance in London, ask for data protect. Well, asking if was true what I say them. I would like confirmation that 2 emails were sent to the Employment Tribunal Watford, the email, the address email of Watford Tribunal, on 8 December and in 2016 and January 2017 from Mark Jones to police.co.uk. Okay. And this email email will copy it in CC to myself, my email. This is the answer. Your request has been under the Data Protection Act of 1998. Anyway. I confirm that Watford Employment Tribunal all the email date 8 December 2016 and the personal date you have in sorry my reading English entitled to under section 7 of the DPA anyway is enclosed. However, please note that email was not copied to you, and what for the tribunal does not hold the email of 11 January 2016. So main, I got this from magistrate in Milton Keynes. Anyway, so the respondent ally, meaning in tribunal, I never talked about this issue. Judge Wolves, I mean, you are a bit confused. I have some health problem probably. I have problem about too many coffee offered from British Petrol, my ex-employer, group of ex-employee. Allora, just want to finish. Multi volte. Looks, this is about funny. He wrote, and I ask, what is it? I ask to pay the anonymous letter my ex-employee £1,768,000. Well, this was on my laws. On my laws, when I write the judge asks for the laws, I can write what I want. What is the problem? This was exactly what I asked for the employee, minimum for what he did to me. But it doesn't mean that I have sent any letter. And he reported exactly the judge what the respondent has brought to strike out to me, and the strikeout from the respondent is absolutely. I don't want to talk anyway. No, but well, I think this is enough anyway. But yeah, I don't know if this video will be seen from the Minister of Justice. What is her name? Just a moment. David Liddington. But Mr. Liddington, we have these people, these criminal people, with Watford Tribunal included, member of the Doyle one. But if some employee is nowhere, is innocent about the law, try to defend himself or herself. What would they expect? But possibly we have to pay a lot of money for the fee in this country. Pay the solicitor, maybe. After we go in tribunal to get the justice done, we lose because this criminal justice, criminal judges, they get paid from the employers. This is absolutely something we have to do. So now their audience, and apologize for my accent, but the concept is clear. Here I'm not stupid, so I continue make a battle, make more video, try to get more people together, because all together will change the system. Now going to the serious fraud office or another NSCA, these are people which they don't care what. But imagine if these people they do something against this corporation or the government. Come on, all together we can do something. So share this video, enjoy my group, and if you have any problem or any question, email me. I will make another, of course, more video and try to spread or contaminate all the internet of my video, and a friend can want to share or download this video and put on the proper channel to try to change this criminal system. Thank you very much. Share this video, enjoy the Facebook group in below the title anyway. Thank you very much, Matteo.